Now we begin the topic of conveyancing by talking about the land sales contract, which later will merge into a deed. But for this segment, this video clip, land sales contract. If this is helping you and you have not yet subscribed, please help us with the YouTube algorithm. Help us get this out there to more people by subscribing to the channel and by liking the video. On to the land sales contract. Now we come to the 8th topic in level 1, the land sales contract.
Which is the first step in the whole issue of conveyancing, in conveying land.
So, what we're talking about here is a whole time frame that you need to keep in mind. It would be very simple, but probably not very good, if we all carried millions of dollars around in our pockets and we walked up to people who have property for sale and said, I like your property, here's $2 million for it.
It'd be very nice if we all had millions of dollars that we could carry around.
I guess if we had enough millions of dollars to settle all the lawsuits and deal with all the problems that would result, there's a real good reason why it takes so long to buy property, why we enter into land sales contracts. So think about a timeline where the buyer decides this is the property I would like to have, and makes an offer for the property to the seller. And the seller accepts the offer and they enter into a land sales contract. Of course, the statute of frauds applies to the sale of real property. So there must be a writing. So we enter into a written land sales contract. Contracts for the sale of land must be in writing, but there are exceptions, and we'll come to those. But for now, think about entering into a written land sales contract. And now some time goes by while the buyer investigates. The seller also investigates whether the buyer really can come up with the funds to do this transaction. So there's investigation going on in both sides. The buyer is checking the property and the title, the chain of title to the property. And all of this is occurring under the land sales contract. Now, on a certain specified date, the buyer and the seller close escrow. And what that means is that they exchange the deed for the consideration, money for the deed.
So they execute the land sales contract.
Now, at the point that money is exchanged for the deed, or some consideration is exchanged for the deed, now the buyer no longer has the protections inherent in the contract. That's gone. Now, the buyer's only recourse if something is wrong is through whatever warranties are in the deed that the buyer just accepted.
Okay.
Because at this point in time, we're operating under the warranties of the deed.
So the deed now becomes the second major step in the area of conveyancing.
And what warranties are there is dependent on what kind of deed was accepted.
So you made mention to a quit claim deed. There are no warranties.
Now, think about how vital that is, what Dennis just said. A quit claim deed. If you were an adverse possessor, you would want to sell the property under a quit claim deed, and you would actually hope that the buyer wouldn't come to realize that you had the property only by adverse possession. Because if you could get the buyer to accept this quit claim deed, there are no warranties with that. Now the buyer has bought a lawsuit. Under the contract, the buyer doesn't have to buy a lawsuit. The buyer has the right to have marketable title. So this point of exchanging the consideration for the deed is vital. Now, after the deed is accepted, it may be recorded immediately, or there may be some time lag before the deed is recorded. In bar fact patterns, in law school fact patterns, there's probably going to be quite a bit of time before the deed is recorded. It may not be recorded at all. And there may be a breach anywhere in this time sequence. And the remedies for that breach will depend on where you are in the time sequence, so you need to keep that clearly in mind. So let's talk about the land sales contract first. it must be in writing under the statute of frauds. But there are exceptions, and the exceptions, the major exceptions are if there's a sufficient memo signed by the party to be charged. And you see that expression all through the law. What is that? Who is the party to be charged? It's the party we're trying to enforce it against. Whoever's being sued is the party to be charged. So we need a sufficient memo signed by that party, the defendant in your lawsuit. And what's sufficient? It has to describe the property, it has to have the identity of the parties, and it has to have the price.
If any, you could give a outright gift of land, and if it's oral and then later on the owner puts it in writing, there's no price because it's free. So that would be implicit in such a conveyance.
Now the second exception is part performance. And for part performance, depends on the jurisdiction, and if you're studying for the bar, it depends on what kind of bar review materials you're looking at, because they're all over the place on this. What we can tell you is that payment alone is not enough.
Right. You can't go up and give somebody money and buy a home without a writing, because that person could say, take your money back. And there's that, the fact that you paid will not get you out of the statute of fraud.
So what we can tell you is that payment is not enough. What you need to have part performance is possession, and in addition to possession, either payment or improvement, or of course both.
And the payment doesn't have to be full payment. It could be partial payment. You've given some money and you've taken possession, for example. That'll get you out of the statute of frauds.
Now, the third exception to the writing requirement is what's always an exception under the statute of frauds, estoppel, detrimental reliance. Now, under the land sales contract, we have the huge issue of the seller's obligation to deliver marketable title. And the rule is that implied in every land sales contract is an implied warranty that at closing, the seller will give the buyer title that's reasonably free of defects, regardless of the type of deed contemplated in the contract. So remember, even under a quitclaim deed, the seller has the obligation to deliver marketable title. So what are encumbrances? What are defects on the title? We have a lot of things that are defects on the title that mean that the seller does not have marketable title to deliver under that contract. Any encumbrances, mortgages, assessments, easements, title gained under adverse possession, violations of zoning laws, any change in zoning between the time of the contract and the time that the deed is exchanged for the consideration. But remember that real covenants aren't considered clouds on the title. Only violations of covenants are.
During the existence of the land sales contract, the buyer has the right to enforce this covenant that requires the seller to deliver marketable title. Now, if there is a breach of the land sales contract, now remember, if you sign a land sales contract, if you're a seller, you have to sell. If you don't sell, you've breached. If you're a buyer, you have to buy. If you don't buy, you've breached.
Our students have a lot of trouble with the idea that if you refuse to sell, it's a breach, and also if you refuse to buy, it's a breach. Our students want to think that if the buyer backs out, no harm, no foul. The seller can always sell it to somebody else.
The seller takes time, effort, energy, and the seller may just want out. Mm-hmm. And once you've signed a contract, you're bound to that contract. Now, the seller or buyer, who, depending on who breaches, has a range of remedies. You can go after damages, basically the difference between the fair market value of the property and the contract price. And let's say the land zooms in value, so the seller says, why should I sell? Well, the reason you have to sell is you have a contract to sell. And let's say the land sales contract says the land's going for $250,000, and now the land's worth $500,000. So the seller breaches. Well, okay, what's the contract price? $250,000. What's the fair market value? $500,000. What's the difference? $250,000. And so therefore, buyer has a lawsuit for $250,000. Buyer can also get, and seller, either one can get restitution, which means down payments or any benefit conferred upon the other party. You're entitled to get that back. And because land is considered unique, you have the remedy of specific performance, which means you can actually, either party, buyer or seller, can, under this doctrine, enforce the terms of the contract and either make the buyer buy or the seller sell. Now, under the doctrine of merger, once the buyer accepts title, as Nancy indicated, the buyer now waives all rights under the land sales contract. Under the doctrine of equitable conversion, and this is the majority rule, the minute the land sales contract is entered into, the buyer assumes the risk of loss. Now, that's the majority rule, so watch your states. California's the minority rule. It protects buyers. California says you only assume the risk as a buyer until you take possession. If you don't have possession yet, or at least a legal right to possession. Once you have that legal right to possession, then you assume the risk of loss if it burns down. So you better get insurance as soon as you close escrow and you have that legal right to possession. But in the meantime, until execution of the land sales contract, well, under minority rule, the buyer does not assume the risk. Under the modern majority rule, in the majority of states, buyers assume the risk immediately as soon as they sign that contract. So watch the state that you're in and see if you don't need to get insurance as a buyer as soon as you sign on the dotted line. If there are defects on the property, modern majority again, caveat emptor.
Meaning buyer beware.
That's right. That's right. No warranty of suitability for fitness and buyer beware. California's contract requires disclosures, but the modern majority is caveat emptor, buyer beware.